присоединяют. Значит, в том, чтобы помочь государству понять, как нужно правильно имплементировать заключительные замечания Комитета ООН против пыток Казахстана и как улучшить ситуацию со свободой от пыток в разных частях. И эта идея родилась у нескольких организаций, они поддержали, и волонтерский проект, как я уже сказала, мы начали в мае прошлого года. Вот сегодня у нас 18-я дискуссия, сначала мы проводили по 2 дискуссии в месяц, а потом решили в августе уже, что это будет по одной дискуссии, потому что информация должна немножко перевариваться. Ну и все дискуссии в записи вы можете найти на нашем канале Dignity 5351 в YouTube. Пожалуйста, делитесь. Чуть позже ссылочку мы в чат поставим. Сегодня с нами, как обычно, как всегда, мы очень благодарны доктор Элина Штейнерте. Она действующий член подкомитета Организации Объединенных Наций по предупреждению пыток. Как вам известно, этот подкомитет создан в соответствии с международным договором, который Казахстан ратифицировал. Называется он «Факультативный протокол по предупреждению пыток» к Конвенции ООН против пыток и дает понимание того, что такое национальный превентивный механизм, каков статус его должен быть, какие функции, что такое места содержания под стражей и так далее, и так далее. Сегодня у нас речь пойдет о содержании в заключении или о местах лишения свободы людей с инвалидностью. И, как я уже представила, Элина Штейнерте у нас главный спикер. Как правило, наши дискуссии проводятся в таком порядке, что сначала выступает спикер 10 минут, далее вопросы и затем само обсуждение. Поэтому, пожалуйста, еще раз представлю госпожа Штейнерте. Она в прошлом занимала позицию или должность, пост, да, руководителя рабочей группы ООН по произвольным задержаниям. Также является профессором нескольких университетов, в том числе Великобритании. Элина, пожалуйста, вам слово.
Спасибо, Анара, спасибо вам большое. И добрый день всем коллегам, друзьям. Очень приятно быть с вами опять вместе. Сегодня у меня презентация по мониторингу растений для лиц с инвалидностью. У меня есть несколько слайдов для этой презентации, но если вы не возражаете, я буду говорить все-таки на английском языке, мне так легче выразиться, но слайды хотя бы у вас есть на русском. И, конечно, все вопросы вы можете задавать по-русски, я понимаю.
Да, и перевод доступен. Внизу нужно выбрать глобус, перевести на русский язык. С нами сегодня работает переводчик Ярослав Штырбу.
Спасибо большое. And so, dear colleagues, today I have been asked to look at 2 issues of disabilities. And what I intend to do today is basically look at 3 aspects in my presentation. But to begin with, I wanted to perhaps explain, because I'm taking slightly different...
Давайте расскажу о структуре моей презентации. В этот раз я решила немножечко по-другому подойти к работе, к тому, как мы будем работать с заключительными положениями, про которые ранее говорила Анара. Как вы знаете,
observations specifically look at the issues of disabilities and what concerns Committee Against Torture has in relation to the provision of care for persons with disabilities in Kazakhstan. What I propose to do with my slides, and I think just looking at those paragraphs, to all of the learned audience here, it is very self-evident, may I say, as to what the issues are. The question, I think, always is, rather than pointing out what has gone wrong, the question is always what can be done in a way to prevent things going wrong in the first place. And so today, with the kind permission of Anara, I have taken this slightly different approach. Instead of specifically examining what has the Committee Against Torture said, rather looking at how could it have been prevented and what can we learn from the jurisprudence and approach of the United Nations Subcommittee on Prevention of Torture as to how these situations can be prevented. How does the SPT, the Subcommittee on Prevention of Torture, approach issues of... I'm sorry? There seems to be an interference. Okay. So what is the approach of the SPT towards monitoring places of deprivation of liberty for persons with disabilities, and what particular aspects the SPT concentrates upon? So 3 elements that I will talk to you about specifically. First of all, what is, very briefly, I know that you are very familiar, but from the perspective of the issues of the rights of the persons with disabilities, the mandate of the SPT, 1. Secondly, very briefly, I will look at Article 4 of the optional protocol and the meaning of the place of deprivation of liberty in the context of the rights of persons with disabilities. And then I propose a very brief touch upon the approach of how the SPT itself, during our country visits, what do we do in terms of monitoring places of deprivation of liberty for persons with disabilities. So if I may ask us to go to the next slide, please. The next, thank you very much. The next one. Thank you. So the mandate of the SPT and Article 4 of the optional protocol. I think we all know that SPT is very different from other UN treaty bodies. So what you have, for example, from the Committee Against Torture, you have the concluding observations, which are based on the interactive dialogue with the state submits reports, the committee receives information from other parties, and then concluding observations are presented as the conclusions of the committee. This is a written peer exchange process. SPT is different. We don't receive reports in that sense. We go to the countries, we actually visit places of deprivation of liberty so that we can see with our own eyes as to what is actually happening in these places of deprivation of liberty. So you could say that as a treaty body, SPT has very much a hands-on approach towards the establishment of the true approach of how people are being treated in various places of deprivation of liberty. Not what the law says or what the authority says or what the NGOs say. Rather, we as international experts make up our own mind, receiving the various positions from the authorities, from the civil society, from the national preventive mechanism, looking at the legislation, looking at the reports, but we also go ourselves and we see with our own eyes as to how things happen. The crucial aspect, of course, is in the context of our discussion today, when we talk about the rights of the persons with disabilities, is the question of deprivation of liberty. Are these people who are in these specific facilities designed for individuals with disabilities, are they places of deprivation of liberty? And this is where Article 4 of the optional protocol comes into place. As we know, there are 2 key elements here. Paragraph 1 of this provision states that any place under state jurisdiction and control where persons are or may be deprived of their liberty, either by virtue of an order given by public authority or at its instigation or with its consent or acquiescence, qualifies as place of deprivation of liberty in the context of Article 4. And it goes on to further explain that this includes any form of detention or imprisonment or the placement of a person in a public or private custodial setting which that person is not permitted to leave at will by order of any judicial, administrative, or other authority. So we are talking about a very wide, all-encompassing definition. And I think for Russian language, it is crucial to remember that it is не только места заключения стражей, но и места ограничения свободы. And this, I think, in Russian language is a particularly important element to remember. And here I also want to take just a minute to give some good news. As I know some of you have been very well aware that the SPT, we have been working on our first general comment. And that general comment focuses specifically on the meaning and understanding of Article 4 of OPCAT. And that general comment was adopted by the plenary of the SPT now nearly exactly 2 weeks ago, and is now with the editors, and we hope that it will be with you very soon. If we move to the next slide, please. Thank you. So deprivation of liberty, what is very clear and what's important especially to emphasize for our discussion today is that the term deprivation of liberty must be understood very broadly. It is not only содержание под стражей, it is also ограничение, лишение свободы. And what is also important, that both public and private settings and situations in which there is state instigation of or consent or acquiescence to the deprivation of liberty are absolutely clearly covered by Article 4 of OPCAT. And this, without any doubt whatsoever, includes healthcare and social care settings, including psychiatric hospitals, care homes, including facilities for persons with all sorts of various disabilities. So what has the SPT done in relation to these specific facilities? First of all, these facilities are included in our field visits when we go to countries, parties to OPCAT, when we visit places of deprivation of liberty. We specifically pay attention to such facilities as social care homes, psychiatric hospitals, places, homes for persons with disabilities. We look at the legislation and we look specifically at safeguards which are placed through legislation and how these are being implemented in practice, especially around the issues of voluntary and involuntary treatment. It is, of course, also the job and the role of the SPT to make sure that those who are on the ground are sensitized towards these issues. So the SPT pays particular attention that the national preventive mechanisms, which are established in accordance with OPCAT, also pay equal attention to these facilities. And of course, it is also about issuing specific recommendations. So if we move to the next slide, please. In the following 3 slides, I have some concrete examples as to how the SPT has worked so far in relation to these various aspects of issues around persons with disabilities and safeguarding these persons with disabilities who are in specific facilities, safeguarding them against any risk of torture and ill treatment. What I have here for you are examples, quotes, exact quotes from public reports of the Subcommittee on Prevention of Torture, where it has visited different states and what it has paid a specific attention. In this first slide, I have 2 examples for you from Latin America, from Argentina and Mexico, and both of these examples specifically look at the issues around the specific legislation with specific focus on safeguards in relation to informed consent and voluntary involuntary treatment. So in relation to Argentina, I mean, I'm not going to read it all out for you. You have the slides in front of you, but you can see that the concern of the SPT is, while there has been a new legislation adopted in relation to the mental health issues in the country, what hasn't happened is that the enabling legislation for this legislative act at the time of the SPT's visit had not been adapted. And as a result, the application of the law has been only partial and very much dependent upon the interpretation, resources, and understanding of each separate institution. Now, it goes without saying that you straight away see the problem right there. There is incoherent application of the legislation, very much open to interpretation. So in terms of the legal framework, while that is existent, its implementation is not there. Somewhat similarly, in relation to Mexico, the subcommittee was looking at the issue of informed consent and notes that in accordance with Article 12 of the Convention on the Rights of Persons with Disabilities, Safeguards must be established for persons operating with the informed consent of the patients exercising the legal capacity. And recommendation here that in order to make sure that this safeguard is fully effective, legal representation is to be provided to persons who are involuntarily hospitalized. So the legal representation here is highlighted as a vehicle, as a tool to ensure meaningfulness to the safeguard of informed consent. If we move to the next one, please. Thank you. So here I have two examples, one from Africa and one from our neighbor, Kyrgyzstan, in relation to the treatment and conditions of detention or deprivation of liberty, shall I say, in the context specifically to places where persons with disability are. So for a change, a good example from Mali, which the SPT visited a psychiatric unit at Point G hospital in Mali, which is the only one in the country, at least at the time of the visit. And here the SPT points out the good elements it has observed, such as an open door policy, which is applied to all patients who are free to move about the establishment, that in terms of the places of confinement, solitary confinement, that these are, even when people are in such places, they are never restrained, and there is a very strict and well-kept daily record of any time when these measures have been taken vis-a-vis a patient. And in terms of the treatment, the SPT also notes as particularly positive the fact that the consent of the patient is always sought, noting that this explains why there are very few forced hospitalizations in the facility. As a further good point in terms of the release, in terms of the discharge of the patient, the SPT also notes that the close relationship that are being maintained between the patient and the family, and how the institution is facilitating this, noting that this also helps the return of the patients to the family and to the community life. As a challenge, the SPT notes that the whole cost of medication and treatment lies solely with the family, and this, of course, makes it particularly challenging to those individuals and to those families who are unable to afford this treatment. This is very much contrasted by the observations that the SPT made during its visit to your neighbor, to Kyrgyzstan, some years ago, where it was talking about extremely poor sanitary conditions in the psychiatric hospital, including lack of showers, putrid smell, filthy, broken, as well as old mattresses and beds, old rundown buildings, overcrowded facilities, no possibility for physical activity, which in the end were so altogether so overwhelming to the SPT that it concluded that these actually amount to inhuman and degrading treatment. And finally, if I may ask to go to my final slide, because this is the final bit that I think is also absolutely important to look at, and that is the discharge. And here I have two examples from you, once again, one from Argentina, from Latin America, and the other to another close by state of you, Mongolia. Because when we talk about deprivation of liberty in the context of disabilities, here I think it is even more important to underline the exceptionality, the absolute exceptionality that must be applied in relation to such instances. And therefore, the SPT is always very much looking to make sure that people are not in such institutions longer than medically required. And here, for example, in Argentina, the SPT was concerned about the lack of intermediate centers to provide gradual social support pending final discharge from an establishment. And therefore, the SPT was observing that many psychiatric hospital patients are not there actually to receive treatment, but because the hospitals, to a large extent, operate as a kind of social welfare centers for persons without resources or family to support them. So the issue of community-based services, of supported living within the community, is a prime concern for the SPT in order to, within the broader mandate of the prevention of torture and ill treatment in such facilities. A very similar point was made in relation to Mongolia, where the SPT was recommending additional measures to be taken to support the establishment of community-based services in order to aid the discharge of the patients who are only in long-term hospital care because they lack of access to community care. So to sum up, from the perspective of prevention of torture and ill treatment, when it comes down to the rights of persons with disabilities in specific facilities, institutions designed for these individuals, there are three key elements that the SPT will always look at in order to prevent the situations amounting to torture and ill treatment. One, it is the legislative framework specific to the healthcare of such individuals, which can and must also resume within itself also the issue of treatment. And here aspects of voluntary treatment, evidence-based treatment is particularly important, and the safeguards around this in order to make sure that the rights of the persons with disabilities are not infringed upon are particularly important. As a second block, it is the issue of the conditions within such facilities and the treatment, how these individuals are treated in such facilities is the second big block of issues that the SPT will always look at. And thirdly, the SPT will always look at the point of discharge. Is the state providing enough support to enable people to live in the community so that the process of deinstitutionalization would be able to take place effectively in the country? I will stop here for now, and I look forward to your questions. Thank you.
Спасибо большое, Элина. И
Thank
давайте
you very much, Elina. Let us begin Q&A. Colleagues, guests, does anyone have any questions? May I, Anara? Testimir, Secretary of the Presidential Human Rights Committee. Deputy head, not head. Okay. I'd like to thank the speaker for this presentation on persons with disabilities in closed institutions. It is quite useful for our country. My question is, so you as a person with high qualification, for instance, what would you say about persons with disabilities who have committed crime and doing time? So category 1 and category 2 disability people. So what do countries, measures do they have to provide support to those people? Because in penitentiary institutions, for instance, if they're unable to move on their own, do you have any cases where people would be assigned to be providing assistance to those patients?
Я просто думала, может быть, я несколько вопросов сразу возьму, или вы хотите, чтобы
I just thought maybe I could tackle several questions at once, or do you want me to do one?
Aspects to your question, sir, that I would like to touch upon. One is the issue of specific forensic units in institutions where individuals with limited capacity are held, those who are unable to stand the trial. But I understand that your question was mainly about the issue of mobility in relation to assisting the individuals who have mobility issues, who are in penitentiary institutions and prisons, for example, because they have committed a crime and have been sentenced to prison. to imprisonment. Now, in relation to such individuals, indeed, it's a particular challenge actually across the world globally, because these institutions, generally prisons, are characterized everywhere by old infrastructure, which is not particularly conducive in relation. There are stairs to be taken. There are little steps to be taken when you enter the cell. Quite often you have bunk beds that people have to climb up in order to be able to sleep. So there are various slow sloping ceilings, which are particularly challenging for individuals who are visually impaired. So there's all sorts of different issues altogether. Different countries deal with these issues differently. There's because the main point here, and I will refrain from giving any examples, because the point is that as a country, you have to find what works in the facilities that you have, and the infrastructure that you have will necessarily dictate what kind of adjustments need to be made in order to ensure that the individuals with disabilities are able to live in these facilities. So there are various specific measures that are taken. The most common, what you will see, is that individuals with mobility issues will be accommodated on the ground floor. They different size beds will be implemented, put in their cells. But when it comes down to issues of somebody accompanying them, somebody being as a support person, many countries you see this becoming as a part of other prisoners. So you have another prisoner who will be kind of a carer for the person with disabilities, prisoner with disabilities. And that sometimes can work in some situations, but again, I would hesitate to necessarily pointing it out as a kind of a panacea, as necessarily a good practice, because while on ground, in some countries it works, in other countries it becomes a source of abuse. Abuse in relation to the person with disabilities, because that person is solely dependent upon the other prisoner, but equally vice versa, that those prisoners who are of, shall we say, lower caste are being the task of looking after the disabled prisoner. So it is a very challenging aspect. And in my experience, the best way of dealing it is taking institution by institution approach. It starts with a thorough review of your facilities. It starts with a thorough review of your prison population. What kind of disabilities do we have? Where these people are? What is exactly their health condition? What are their needs? And then trying to see how this can be accommodated. And may I suggest that none of this will be achieved successfully in the framework of both OPCAT, the Optional Protocol to Convention Against Torture, and the Convention on the Rights of the Persons with Disabilities, without proper training and continuous training of your prison staff. Thank you.
Thank you so much. Спасибо большое, Elina.
Спасибо большое. Далее следующий вопрос.
Thank you. The next question is Musa Gali, human rights advocate, specializing on people with disabilities. Over to you. Good afternoon. I will keep my video off, if I may. My question is, but first, allow me to start by describing the situation. So we have a person with disability. No matter what category of disability it is. So they find themselves in an institution. So under the law of Kazakhstan, an individual rehabilitation program is supposed to be developed for that person, for them to be able to receive goods and services. However, I believe that if these closed institutions we are talking about, what we could do to decrease the budgetary pressure, what is done is that this program is usually amended or not implemented at all. And it is done to alleviate budgetary pressure. So under the convention, indeed, assistance is supposed to be provided for those people in closed institutions. For instance, and if it is a psychiatric ward, then it comes as a matter of course. So under the law, to receive goods and services, you are supposed to sign a special agreement on the Ministry of Labor website, and this is what enables you to provide a good or service. So my question is, could the legislation be amended based on the fact that when a person enters an institution without having any means to pay for goods or services, so do they have the right to receive goods or services without paying for those and using the services website for that? So maybe representatives of the Human Rights Office could give an answer to that. Thank you. Let us ask. Here we have several representatives of government agencies, or at least we have invited several government agencies representatives. So anyone would like to address this question? Not yet. No volunteers so far. So let us continue. Maybe someone will answer this question later. I think the speaker is expected to give an answer. So this question is for government agencies. However, we do not have any representatives of those. So, esteemed speaker, could you give us some best practices used globally? What would your advice be for Kazakhstan? What I want to say is a bit different, because I will abstain from commenting on the Kazakhstan legislation, but in any country, if it is a legislation issue, it means that this isn't the whole story. So the key thing is the implementation and enforcement of said legislation. And if we see that it is implemented in such a manner that the rights of a person with disabilities or any person, if their rights are infringed upon, then something is wrong. So it is either a legislation issue or an implementation issue. And from an international rights standpoint, from the OPCAT point of view and the people with disabilities convention points of view, the key thing is for those rights to be upheld. We have a hand, Oljas, and then I will give the floor to Gulsaran. So Oljas, good afternoon. My question for Elina is as follows. We had a case. I was addressed by a person with disability who was on parole. He was a citizen of another country. So when he got released, he needed to find a home, and being a citizen of another country, he had no opportunity to find a job because he didn't have any Kazakhstan papers, the Kazakhstan papers necessary for that. He didn't have any opportunity to receive medical care or place to live. That's why he addressed me and asked me to help him. I found him a home, taught him how to work, how to use computers. However, in theory, I had no right to do that because I helped him to find a job, because basically I was helping him to violate the law. Well, and it was during the COVID pandemic, and he fell ill, and we had to invite private doctors because he couldn't go to the hospital. However, the most terrible thing was that as his parole ended, they decided to deport him after the 18 years of liberty deprivation he spent in Kazakhstan. He wanted to go to Azerbaijan, but there were many legal issues, and we spent a lot of time trying to resolve that. However, he ended up being deported. He's in Baku now. Fortunately, he's doing well. His friends and colleagues have helped him. But all in all, what global practice would you recommend to be applied for this case?
Спасибо большое вам. Да, это очень трудный вопрос.
Thank you. It is a difficult one indeed. First of all, I cannot give comments on individual cases. That's why I am only able to give general feedback. I think what you did is what was possible to do in that situation.
When it comes down to the deportation of foreign nationals following the serving of the sentence, this is a very difficult issue. And I'm afraid that there is no uniform practice when it comes down to international law. There are elements in terms of the provisions of non-refoulement, but I understand that in this case, that is not an issue. There are also issues around the right to a private life and right to family life, which could be at stake. And in the context of the Council of Europe, for example, and the European Convention on Human Rights, that might have also been a factor to take into consideration. It is a little bit difficult, of course, because while Azerbaijan is a state party to the Convention, European Convention on Human Rights, it is not the same for Kazakhstan. So I'm afraid that in terms of the legal framework here, it is a little scarce. But from what you described to me, you've done pretty much everything you could.
Спасибо, Элина.
Thank you, Elina. The next question or comment. It is in chat. Gulsayran, over to you. Can you hear me? Yes. Two questions. The first, in institution number 14 at the village of Zarechne, we have a person who is doing time for 7 years, Mr. Karimbayev. For a theft he never committed. And for the last 2 years, I've been putting a lot of effort into trying people to get back to his case and appeal it, because I have a lot of evidence for this case to be proven forged. So I wonder, could you assist me with this case to be worked on again? The second question, it's the same institution, number 14, in the village of Zarechne. A person with vision issues is kept, sentenced for 5 years for fraud. So he embezzled some money provided from the government, and his guilt was proven. However, government agencies kept this crime a secret for a long time, and it's only after many years that he was put into an institution, and even after he was sentenced to 5 years, he continued to work. So he would work while on paper he would be kept in an institution. So I think in this case, we need to get those government agency officers to be disciplined, because as they kept it secret, they violated the law. It is a criminal offense. Well, as Elina, being an independent international expert, is unable to give comments on individual cases, allow me to address your question. So if you have gone through the whole procedure in Kazakhstan, you have the ability to address international institutions. If it is a person with disability, you can address the People with Disability Committee. So in Kazakhstan, anyone has the right to address that committee. So please be aware of the fact that you have the ability to address that. As for people with disability, if we are talking about the conditions in which they are kept in an institution, you can address the Human Rights Commissioner. You can address the Human Rights Ombudsperson or Commissioner. We have some people representing its offices in the regions. You can address them and receive recommendations on what would be best for you to do. Also, I know that representatives of the Penitentiary Institution Committee either are here or will watch the video of this meeting later, so you can address them as well. And now I'd like to give the floor to Sergey, member of the NPM Coordination Committee from the city of Pavlodar. Good afternoon. It's a great thing that issues like that are raised. So on a regular basis, we have cases like the one Oljas mentioned. And I think those are indicative of certain gaps in our legislation, things that need to be fine-tuned. However, as a member of the Coordination Council and a psychiatrist, I must say that we keep having cases that are indicative of those issues. However, no legislation refinement is taking place. Why? Because I think the reason is that people in our government are quite heartless, and there is a lot of rotation. People come and go, and some unqualified people make a lot of mistakes, then they leave, then others come, and we see that the quality of our ministers leaves a lot to desire. Mr. Bishombayev being a prime example of that. For instance, the case of Vitaly Kazantsev. He is 15 years old. He lives in the village of Aktas. And the Aktas institution is an institution for adults. It has no infrastructure for children, for teenagers. It has no infrastructure, despite the fact that Kazakhstan has ratified Children's Rights Convention, People with Disability Convention. However, when a case like that arises, we will address the General Prosecutor's Office, the Presidential Office, and we will see no response whatsoever. So I wonder, what could you do to fine-tune our legislation to eliminate those gaps? Because, for instance, coming back to Kazantsev's case, I think our chief psychiatrist could establish a body, an institution where teenagers like Mr. Kazantsev would be kept. Same situation with people with disabilities. At times you will have situations where you cannot do anything at all. And this when people like Oljas or NGOs assume the government functions and do this work. And I wonder, so Kazakhstan has ratified those conventions. However, they are not implemented in practice, despite the fact their status is second only to the Constitution itself. So I would like to address our government officers. So you receive a good salary, you are supposed to be doing good work. So why is that we keep having these cases? Thank you, Sergey. You've raised a case that is mentioned in Articles 31 and 32 of the provisions. I'd like to emphasize that the committee was seriously concerned not only with the legislation as it provided its recommendations, it also paid special attention to forced hospitalization for persons with disabilities. Because 18 children were possibly hospitalized either for treatment or monitoring. And one grave concern that the committee had was about safeguards, because first of all, we have a child that is kept in an institution for adults. The second thing is that we know that under the criminal code, it is supposed to be different. So even that situation is illegal in itself. The second thing is that if we are talking persons with limited legal capacity, children or people with disability, they require special attention. So, Sergey, we've spent many years discussing NPM and ombudsperson reports that are indicative of children being forcefully treated with harmful medications. And mind you, it is children we are talking about. And I think if it comes to children, government needs to have a special policy, because not only do they have limited legal capacity, but they are also vulnerable. And the committee also described 4 cases when children with disabilities died in a state institution in Ayagoz. And so far, we have no information about that whatsoever. So it's been 4 years since COVID. So much time has passed, and still we have no information at all. We cannot say whether any measures have been taken place to address the situation, or if situations like that continue to take place. The committee provided a large block of recommendations. First, to avoid involuntary admissions to close institutions on medical grounds, ensure that such admissions applied only when strictly necessary. Second, to develop a public policy aiming at averting the utilization of children and ensure that juvenile offenders diagnosed with mental disorder or with intellectual or psychosocial disabilities are never detained or imprisoned in psychiatric wards. And the fourth one is to investigate promptly, thoroughly, and impartially all allegations of human rights abuses, and ensure legal visits to such institutions by the NPM in cooperation with the Commissioner. So, Elina, what comment would you give? What is the international practice? Where are people like that supposed to be kept? Or is it that children with disabilities who are also offenders cannot be kept in an institution at all?
Anara, the answer to your question is well, of course, it is very complex, but it is in a way very similar to what we talk about adults who have issues, who are, have disabilities. First of all, it is their health. They need to be in institutions which are adapted to their health needs. So if we are talking about individuals with psychosocial disabilities, their treatment is the prime concern and prime issue here. So they need to be in institutions that are specific to that are geared to medical treatment, which is appropriate in their individual case. When it comes down to how it is translated in practice, many countries are struggling with that, in that quite often we are talking about very small numbers, luckily, on one hand, of course, because we want our children to be healthy. But from the perspective of the criminal justice system, this poses a problem, because you might have, a handful of cases, one or two. So the challenge that many countries face is that if you, especially in a big country, you might have a specialized institution where the children are sent, but then that means that they are sometimes hundreds of kilometers away from their families, which then poses a challenge in relation to their rights, in terms of how families are able to visit them and how these children are able to maintain the social links and the family links. There is no one size fits all answer here. And these cases are enormously difficult and complex, and they require a multi-agency approach usually in order to determine how the particular child is approached, how the case of the particular child is approached. Because if you are talking about children who are in conflict with law, there really are a multitude of elements here that comes into play. Because on one hand, you have the criminal justice response, and we all know the general comment 24 of the Committee on the Rights of the Child, and the emphasis on diversion and on prevention that is the basis, the whole raison d'etre of this general comment. But you also have the right of health of this child in question that needs to be addressed. And in these situations, it is very challenging to find the right accommodation. And the only way to do it in practice, what we see many countries doing, the only thing that seems to yield some results, is the multi-agency approach, finding the right facility, finding the right approach to this child. It does require the state authorities not to do the usual, the inertia, just send them there, this is where they go, but to have that tailored approach. It does require that. There is no easy answers.
Благодарю, Элина.
Thank you,
Да,
Elina.
есть ли еще желающие что-то сказать?
Да, можно, Анара, вопрос у меня, да?
May I?
Да, Жанара Балкабаева, адвокат
Жанара,
Казахстана.
Ага. И можно я
defense
видео
lawyer
сделаю
from
теперь удобнее?
Almaty.
Всем, я вас
I will
благодарю за
keep
то, что
my
вы
video
подключили к
off.
такой конференции. Очень
Thank
вопрос
you for
важный.
joining
И
in.
благодарю спикеров также. У меня
A
такой
serious
вопрос.
issue
Вот
indeed.
уже поднимался,
I'd like to thank the
поднималась
speakers.
тема
My
обязательного
question is,
инвалидности, называлась даже
so
фамилия,
this case been
учреждения
raised before.
области. И
I'm
вот,
talking about the case when a person is
ну,
kept in an institution in
учреждение соглашается
Almaty
с тем, что они
region.
могут содержать осужденных
And we see
инвалидов,
that
ну, в качестве
institutions are
наказания,
unable
так как нет условий содержания.
to work with
Этот, значит, осужденный продолжает содержаться.
people with
Скажите,
impaired
пожалуйста,
vision.
вот вопрос к спикеру.
But
Какая
despite this
международная
fact,
практика?
this
Что
person
делают,
is still kept
значит,
in
в
that
развитых
institution
странах,
where no
когда нет
conditions are
условий
provided.
содержания для
So in
инвалидов
developed
совсем
countries,
отсутствуют?
when an
И
institution
что могут сделать
is
в
unable
нашем
to provide
случае?
the necessary
Предполагается ли
conditions for
отсрочка,
a
либо какие-то другие
person with
методы?
impaired
И
vision,
этот вопрос, наверное,
so
также
what
представителям
is
наших,
going to be done?
представителям
So will it be a case
нашим
when
представителям
they will
государственной власти,
do their time
вернее,
later
с теми, кто там есть вообще
once
из Казахстана. Вот мы
conditions
даже не можем
have been
передать своему
provided?
подзащитному
And
часы.
if
Этот
this
человек
our
не может
system we're
зайти в
talking
СОС,
about,
не
then
может ориентироваться
we
никак.
even
Вот эти
have
вот часы
no
Брайля,
ability to give
по
them
которым осужденный
a braille
визуально слепой может ориентироваться, даже не
watch.
можем добиться,
So
чтобы
that
их
person
разрешили. Какая практика
is
международная?
unable
Вот такой вопрос у меня. Спасибо
to
за
even
знания, благодарю за
be able to understand what time it is now. And what's the international
ответы.
practice
И
on that?
надеюсь, что получу обратную реакцию
Thank
со
you
стороны представителей
for your
государственной власти.
questions. And I also hope to receive feedback from government agencies, officers.
Thank you very much. I will not comment on an individual case. It would not be appropriate for me to comment on an individual case. However, looking at the general practice, what we must always remember is that Article 10 of the International Covenant on Civil and Political Rights requires that all persons deprived of their liberty are treated with dignity inherent to their human dignity, with respect inherent to their human dignity. And this requires that if a person with disabilities is in place of deprivation of liberty, that in no way alters the obligation of the state to treat these individuals with the same degree of respect towards their dignity. What we see in other countries is, again, in a similar way, if there is a facility that is unable to accommodate the specific needs of this institution, then another facility must be found. Exceptions must be put in place because at the end of the day, here it is the duty of the state that emanates from Article 10 of the ICCPR, the International Covenant on Civil and Political Rights, and it is the whole Mandela rules set that requires, and these are obligations that rest with the state authority. And saying that we are unable to accommodate that simply does not meet the threshold of the obligations which are imposed on the state. It is, from the perspective of international law, relatively simple. When it comes down to practice, it is the efforts and what measures, and this is what international bodies such as the Committee Against Torture will look, well, what has state done in order to meet its obligations? I will give you another example here from a different context, from a different country. During a visit to an immigration detention facility, there were two individuals, a husband and a wife, in the same detention cell. And the authorities explained that normally they have separate cells for female detainees and for male detainees. In this particular case, the two individuals are kept together because they are husband and wife, and the wife suffers from severe anxiety, and her husband was evident is caring for her, looking after her. So this institution was in a very difficult position they had to accommodate these two individuals, of which one was in a very high agitated mental health, nearly mental health crisis situation, because she was about to be separated from her husband, because the rules of the institution was that these are the cells for women and these are the cells for men. So the director of the institution requested the couple to write zapros, a request, that they would be accommodated together. And on the basis of that request, they were accommodated together in a cell, together, two of them. The reason why I'm making this example is that what the director of that particular institution did in this case was not prescribed in the regulations of the institution or in the laws or in whatever. But on the basis of situation, he did what he could to meet the best needs of these individuals. And what I'm trying to underline here is that when there is a will, there is a way.
Благодарю вас, Элина. Достаточно интересный
Thank you,
пример.
Elina. Interesting example indeed. Could be used as guidance. We have another hand raised. Elena from the city of Pavlodar. And we also received a comment from Jaslan on the implementation of the provisions of the UN Disability Committee, which Kazakhstan received in March. He gave us a link. But Elena, in the meantime, the floor is yours. Good afternoon. Well, when it comes to persons with disabilities in closed institutions, I think this is an issue that is pertinent indeed for Kazakhstan. It is a major one. So first of all, part of the issues that could be resolved with the legislation having things such as parole or delayed imprisonment. So in theory, it is possible to have that, but in practice, courts just don't use those opportunities. So we don't have anything like that. And another case, and when we have a person die in an institution, so first of all, if you are in institution, it's very difficult to be recognized as a person with disability. And if they have, for instance, oncology or another terminal disease, then you are very likely to end up dying in an institution. And even people who are dying are denied by courts to be recognized as persons with disability, despite the fact that we have Decree 530. So even when we have cases like that, courts do not take any action. So I think it would be nice for our courts to pay more attention to that. And recently, there was a round table held in Astana where judges said that, well, even if there are grounds for that and we have a dying person who is supposed to be released under that decree, it is a right that court enjoys. It's not a duty. They do not have to exercise that right and make this decision. So I think this issue needs to be given more profile, because under the law, it's supposed to be different, but in our case, courts will rather have people than be recognized as ones with disability. Because in those institutions can't accommodate those, cannot give proper treatment. Anara, may I? Yes, of course. And then I will give the floor to Ruslan. Thank you for organizing this roundtable. Indeed, these are issues that are pertinent for our country as a whole. And I wonder, have you invited our disability ombudsperson, Mr. Seyjanov? Because I think in future it would be nice to have them present. Unfortunately, I do not have his contact details. I will send you his phone number. Okay, thank you. Because he needs to be here. Like that ombudsperson needs to be invited. And same with the children's ombudsperson. Ruslan, representing Equal Access Initiative in Astana. And I'd like to give follow-up on Elina's words. I'm a victim of torture. I've been recognized as such. So as I was kept in an institution for 8 years on a case that was forged, I had no accessible environment. I was there 2009, 2017, and my illness was on the list of illnesses that provide for persons to be released. However, courts just disregarded that, and they said that all in all, the situation is that I spent all those years and I was supposed to be released, but never was, and it's a violation of my rights. And another thing, when it comes to abuse and torture, if we have a person with disability who has limited mobility, then they can be given offense, but they're unable to leave the cell to just put an end to that abuse. Thank you, Ruslan. I'll remind you that Ruslan's been recognized as a victim of torture under 2 articles of the International Covenant, the UN Human Rights Committee has said that Articles 7 and Article 10 have been violated. Article 7 is prohibition of torture, and 10 is prohibition of inhumane treatment of prisoners. And this is the only case we've had when 2 articles have been violated, which is quite rare. However, I think based on what you have heard so far, we've had individual cases, and I think if we have a look at the big picture and comes to closed institutions, and by closed institutions, we mean any closed institutions, no matter of what kind exactly, be they ones governed, managed by Ministry of Defense or Interior or Health or Education. So we need to accommodate people with disabilities no matter where they are. And this is not only is it something that's mentioned in the latest report, but also this is a stance of the Torture Committee. I think Elina may have some comments. Elina, are you here? Yes, I'm here, but I don't have any concrete recommendations to give. What I want to say has been said before. What's important is to remember that Article 10 is in the international contract, and when it comes to cases like that, we need to remember that this article is not only about people kept in prisons, but people kept in any closed institutions. Same with Article 7, which prohibits torture. This is something we need to keep in mind.
Благодарю вас. Если есть комментарии от представителей государства, было бы супер услышать их сейчас.
Any comments from
Возможно,
government
в
officials,
образовательных учреждениях у нас
maybe
всегда
from the
присутствуют
educational institutions?
учреждения МВД,
We always have
Устинский, Актюбинский,
the
юридический,
Almaty and Aktobe
Костанайский.
lawyer institutes, the Aktobe one, the Kostanay one. Is there anything you'd like to say? Maybe you have something, some plans for implementing those recommendations or some ideas, because unfortunately, we, human rights advocates, have no idea whether there is any planning being done on the implementation of the provisions from the UN Disability Committee, because we have the national plan that was approved last December, but that plan doesn't have any information on that avenue of work. And maybe one of our recommendations from today would be to establish a concrete plan on implementation of the provisions from the Disability Committee, Torture Committee, and Children's Committee, because we see that there are quite a few issues raised by the Torture Committee. However, we see that no progress has been made so far, because institutions cannot accommodate people that have issues, for instance, that are visually impaired. So one cannot even give them a braille watch. Or if it's a person like Jasulan, then they're unable to go out and have a walk. And if it is a lockdown period we're talking about, then many institutions have stairs, flights of stairs. And in a country with a climate so cold as here, it's very difficult to go down those stairs even without a wheelchair. So even if you're a healthy person, it's quite difficult to go down the stairs, almost impossible. Musagali, you want to say something? Thank you. I just wanted to give some more information. So you mentioned the national plan. I think papers like that needs to have statistics in them on persons with disabilities in closed institutions, because even us, people who are free and enjoy all of their rights, we still only have limited access to information in our native language. So our access to information is rather limited. And I think if you are in an institution, it must be even worse, because you have no gadgets, you have no access to information whatsoever. I think in their case, they have no access to information in either Kazakh or Russian languages. Indeed, even people not in institutions have difficulty exercising many of their rights. And of course, with persons in institutions, it's much worse. However, in this case, we are talking about freedom from torture. This right is enshrined not only in Kazakhstan legislation and national agreements it has signed, but also Kazakhstan constitution by Article 17 of the constitution. And a person's dignity is the source of all rights and freedoms. And it also says that no one will be subject to abuse or torture. And moreover, Kazakhstan has Article 146 in its criminal code, part 1 of which says that abuse is a criminal offense. And I wonder, under this article, so 146 of the criminal code, part 1, if we see that institutions cannot accommodate persons with disabilities, then we see that it means that there are government officials who do not take measures for the necessary conditions to be created. And even back in 2013, when we raised that issue for the first time, the General Prosecutor's Office had concerns about its implementation. So we saw that human rights advocates were for this provision to be put into the legislation. However, the government officials said that back in the day, they didn't have any ability to accommodate. And it's been 10 years and nothing has changed. And another thing that no one has mentioned, women with disabilities, because if it is a woman with disabilities, then it means that this person is even more vulnerable. And I wonder if any of you would like to ask questions related to women with disabilities in closed institutions. Mr. Gali? Oh, I just forgot to lower my hand. Well, if there are no volunteers, let us address the next issue, support for families. What does it mean, preventing children from being put into an institution? What does it mean to provide support to families? So what measures does the government take to provide help to the families of people with disabilities? Can you give any cases? No hands raised. Then let's do the next one. So psychiatric treatment, necessity for that, provision of housing and psychosocial support. We know that there are UN principles for protection of all people with mental issues, and those people have special rights. However, in our mental health institutions, they do not have any specific facilities where people could have some time on their own. Because, well, these people, they are to enjoy the same rights as everyone else. And it means that they are supposed to be able to have the right to privacy. And in Kazakhstan, we see that no measures are being taken. And when it comes to people with mental health issues, we realize that this right is paramount because it keeps their health from deteriorating. However, and I don't know why, but this issue is usually not addressed by consolidated reports. So why is it that our Ministry of Health hasn't established those special rooms where people could exercise their rights to privacy? The second one is what needs to be done to ensure that this right is ensured for people with mental health issues. Because I know that there is an institution where people sentenced for life are kept, and institutions like that are supposed to have psychiatrists. However, psychiatrists don't always want to go to such institutions as they see it as an unattractive job. And we've had a case where a person was kept for a year in solitary confinement, and we've had a discussion on that previously. So a person spent a year in solitary confinement, and it drove them mad. And they would do things that a sane person wouldn't do. That person continues to be kept in criminal justice institutions, as far as I'm aware of. And as Ms. Steinerte has said, that institutions, first of all, need to accommodate those people to establish necessary conditions, and the balance needs to be found between the right to privacy, the right to health. And my question is, what recommendations would you give to the government? And I'm now addressing either the speaker or civil society, or maybe government officials would like to say that work is being done on that already. So we want it to go beyond discussion. We want these proposals to be implemented. A recording of this session will be kept on YouTube. So should you have recommendations later, or should you like to return to this meeting, you will be able to watch it later. And another thing we need to address is compensations, redress to people with disabilities should they have been subject to mistreatment. And also we need to talk about control over using chemical and physical means to calm them down, because under the National Covenant, one needs to secure consent to be able to do anything like that, because without consent it would be seen as mistreatment. So how is that regulated in Kazakhstan? I think this is something that is very rarely discussed at either civil society level or government level. And it could be physical or chemical. One could even use weapons to pacify those persons. So all in all, we see that those prohibitions only cover some general things, for instance, what, but do not have sufficient detail. And another thing I'm interested in, so when it comes to means of suppression, how are they used in Ministry of Health institutions? Does anyone has information on that? So Sergey writes, so as I work on each consolidated report, I always give a recommendation to ensure patients' rights to privacy. Okay, why is it that they do not have those rooms then? Greetings. Indeed, as Anara has said, I am the person working on consolidated reports from the Ministry of Health, and I will always add in this provision saying to ensure the right to privacy, and I will cite the UN resolution dated 1991, which says that any mental health institution patient has the right to privacy, and I kept doing it for years. No response so far. So when it comes to government agencies, I think the Ministry of Health is the only agency that will not respond to our requests and reports. Because, for instance, Ministry of Education will give us well-substantiated responses, while the Ministry of Health will only give us one paper saying that we have taken note of your recommendations, we'll be working on that. That's it, nothing's been changing. And I think in Kazakhstan we have major psychiatric issues. And I think when you go, for instance, to cardiology or other units, you see that, well, for the last 33 years that Kazakhstan's been in development, a lot of progress has been made. But when you go to a mental institution, you see that it is still quite the same as it was back in the Soviet era. And another provision I will add is pay close attention, please pay close attention to previous consolidated reports. I think our psychiatry doesn't really have rehabilitation. Another thing I find concerning is that we used to have Mr. Altenbekov as chief psychiatrist, and now we have a relative of his in the same position. So we see that I think office will be inherited, and it would be okay to have that in a private institution, but this a government institution we're talking about, which is managed by a family, I think this is wrong, and no progress will be made as long as President pays special attention to that avenue of work and changes all of those people managing that. And if you have a look at all the recommendations I provided since 2014, you see that nothing has changed. Too many people, not enough beds, bad nutrition, no right to privacy. And I always ask our government officials, so your salaries are rather high. Your salaries are amazing, but why is it that you do not aim to change anything for the better, anything at all? So we've been discussing so many things that could be improved. Why is it that you put no effort in? Why is our legislation violated and no one bears any responsibility? known as accountable for that. And another, coming back to your question, I think privacy is paramount, yet it is violated. Why? Because we have this decree on providing mental care to people with mental issues, which says that those people will not have right to privacy, because if they were provided with those privacy rooms, that they would be likely to commit suicide, which means that Kazakhstan is taking a different stance from the rest of the world. And besides, I think our mental institutions just do not have the budget, it seems. However, based on what I know, psychiatry receives the same funding as all other medical areas. So I think they need to be brought to order. And I think, but Anara, am I correct in thinking that we have no Ministry of Health representative here? Thank you, Sergey. Well, we have Deputy Head of the Human Rights Commission, Mr. Abishev. I think he will raise this issue because, as he said, it is important to have ombudsperson present at meetings like this one. And we have representatives of Mr. Rostaev's offices in the regions. So I think they will take note of that. We have another recommendation from Musagali to adopt an ethical code for working with people with disabilities that are kept in closed institutions. And now, to conclude this session, I would like to give the floor to Elina.
Thank you, dear colleagues, and thank you for the very detailed and very pertinent discussion. In my concluding comments, I only would like to highlight a couple of fundamental points. When we talk about the persons with disabilities and the right to be free from torture, inhuman or degrading treatment or punishment, I think it is important to recall that that right, it's nothing special. It applies to everyone, be it a person with disabilities or not, be it a woman or a man or a child. It applies simply to everyone. What is important to understand and underscore is that in situations when a person is in a situation with disability, whatever type of disability that might be, in order to reach that obligation, the right to be free from torture and ill treatment, accommodations and special arrangements may need to be made, because what might amount to ill-treating me, somebody who doesn't have a disability, to somebody with disability, we all know it will be completely different. What is important when we discuss these issues from the perspective of the Convention Against Torture is to remember that persons with disabilities, various disabilities, could be in a whole host of situations which involve deprivation of liberty or limitations to liberty. These could be individuals who have been sentenced by court, who are in prison. These could be individuals who are only awaiting trial. They might be in police stations. These might be individuals who are unable to stand trial and are in specific forensic units for treatment because they are unable to stand trial and have been recognized as such by the court of law. There could be healthcare settings. These could be psychiatric institutions. These could be social care homes. These could be specific facilities for children. These could be also facilities for people who use drugs, for example, or treatment facilities for people who use drugs, or just generally treatment facilities. And I think from the perspective of prevention of torture and ill treatment, it is very important to recognize the plethora, the whole rainbow of facilities that need to be part of the monitoring mandates of the national preventive mechanisms, and that are part of these of the mandates of these mechanisms as well as of the SBT. It is important to remember that, however, everything in a country starts with the legislation, and it starts with the proper implementation of that legislation. There will always be difficult instances. The единичные случаи, as Mr. Molchanov, I think, mentioned earlier. But these exceptions does not mean that the rules for the rest shouldn't be applied in a way that they are dictated by the international human rights treaties. And therefore, it is absolutely paramount, I think, that discussions like these take place from people who work with these issues, who know what the situation is on the ground, who are therefore able to say this provision of the law is not being implemented the way it should, or this situation is not regulated by law at all. So thank you very much for this discussion, and thank you for having me. Goodbye.
Благодарю вас, Элина. Напомню только,
Thank
что
you, Elina.
речь шла о лицах с инвалидностью.
May I remind you that today we have talked about
Достаточно большом пласте вопросов.
persons with disabilities in closed institutions. We have covered a host of issues. The only thing we haven't covered is discrimination. And our recommendation would be to issue legislation prohibiting discrimination, because in Kazakhstan we have discrimination everywhere. And this prohibition, it needs to be for discrimination on any grounds. And it is enshrined not only international legislation, but our constitution. And we need to have our legislation reflect that. Today we have covered a host of issues, because we've said that there are free people with disabilities, there are people with disabilities in closed institutions, be those mental health ones, children's ones, Ministry of Defense ones, or Ministry of Defense hospitals. Not long ago, we had several cases, at least 2 cases of the last 10 days, when soldiers, recruits who were healthy, were put into hospital and were in a coma. So, and as we say that people need to be treated the same, no matter whether they are in closed institutions or not. So if we see that there is a rehab program or a family support program that can be enjoyed by a person not in an institution, it also needs to be for people in institutions. Besides, there are people who are especially vulnerable. For instance, those are children or women with disabilities, or nationals of other countries, which makes them even more vulnerable. And this is what Elina talked about earlier. So we need to pay attention to how we treat those people, because at times, for instance, the same treatment is okay to have for a person without disability, but inadequate for a person with disability. We've raised many questions, many issues, and said that government needs to treat various medical areas of medicine equally, because psychiatry has remained the same as it was back in the Soviet period, despite the fact, and that might be due to the fact that it doesn't have enough funding. Also, there are children with disabilities There are not many of them. However, there are some that are kept in closed institutions. And the key thing is for them to be close to their parents. They need to be accommodated. And we need to be mindful of Kazakhstan's international obligations based on those and other countries' positive experiences. Let us come back to the case that Elina gave us, that we had a head of institution who put wife and husband into the same cell, which was humane, because that woman had anxiety issues and needed special care. So her psychological condition was taken into account. Also said that at times people with disabilities will be treated so badly as to end up dying or commit suicide, and we don't know the numbers, and we need to do awareness raising for government officials to avoid discrimination and respect everyone's rights. A plan needs to be developed which would have statistics on those people and would provide information on actions that have been taken and to be taken, including on that case where 4 juveniles died during the COVID period. And a recommendation has also been provided on developing an ethical code. One thing that has not been mentioned is that it is important to implement provisions and decisions already made on Kazakhstan. For instance, let us get back to Ruslan's case. A person with disability, he has mobility issues, and the government needs to compensate them for that, for what he had to go through as he was kept in an institution. Because, as you remember, a criminal sentence doesn't mean that a person needs to be prevented from exercising their rights. Yes, their liberty is deprived, but they enjoy the same rights as everyone else. And that does it for today. I thank all of the participants in this discussion, and I am hopeful that government officials, human rights advocates, and other people will take note of these issues, and you will be demanding for international safeguards to be exercised, safeguards for people with disabilities in closed institutions. And one last recommendation would be to write a report on people with disabilities in closed institutions. I think it would be nice if you publish that this year. If you require assistance in developing maps or questionnaires, will help you with that. I'd like to thank Elina and Yaroslav. Thank you. See you later. Bye.